seated.
The Caribbean Court of Justice, Appellate Jurisdiction, on appeal from the Court of Appeal of Barbados, delivery of judgment in the matter, BBCR 2023-001, between James Ricardo Alexander Fields and the state. The members of the judgment delivery panel are the Honorable Mr. Justice Saunders, President and Presiding Judge, the Honorable Mr. Justice Anderson, the Honorable Mr. Justice Barrow, and the Honorable Mr. Justice Burgess. Counsel, you may now enter your appearances.
Pleases this honorable court. I'm Andrew Pilgrim. My appearance is as before with Mr. Marty Garnes.
Yes. Good morning, Your Honors. If it pleases this honorable court, I am Neville Watson, and I continue to appear for this state in this matter with Mr. Rudolph Burnett, my learned colleague.
Yes, thank you, Counsel. As I indicated a short time ago, Mr. Justice Witt, who took part in this appeal, is indisposed. The appeal was largely concerned with whether the jury was misdirected by the trial judge on how to treat with a witness whom the jury considered may have been deliberately untruthful in one or more particulars in his evidence. The appellant argued that the direction to be given to the jury should follow the direction approved by the Court of Appeal in Canterbury against the Queen, and for convenience referred to as the Canterbury direction. That direction is to the effect that if the jury finds that a witness was deliberately lying on oath, then the jury must reject the whole of that witness's evidence, because if the witness lied in one matter, they would be quite capable of lying on another. The respondent, the DPP, disagreed that this direction was a proper one and contended that issues of credibility and reliability fell within the exclusive competence of the jury. The DPP relied on the Eastern Caribbean Court of Appeal decision of Nelson and the Queen, and also on model directions from various jurisdictions. The facts giving rise to the case are that on the 23rd of July 2010, the appellant was arrested and charged with murder. He was indicted on the 3rd of September 2012 and was twice tried in the High Court, but each of these proceedings resulted in a mistrial. At his third trial, he was found guilty of manslaughter and sentenced to serve 16 years in prison. The state's case against him was that on the 18th February 2010, he was engaged in the sale of cocaine rocks in his neighborhood. One of his customers, Mr. Michael Dare, was dissatisfied with the cocaine he had purchased and demanded the return of his money. Mr. Dare attacked the appellant, who drew a firearm, shot Mr. Dare dead, and then fled the scene. An eyewitness, Mr. Geoffrey Carter, gave evidence for the state, and during his cross-examination, it was demonstrated that he was untruthful in at least one aspect of his testimony. In his summing up, the trial judge directed the jury along the lines that if the jury found a prosecution witness to be lying, quote, you are entitled to reject that particular detail. The fact that you do not accept a portion of the evidence of a witness does not mean that you must necessarily reject the whole of the witness's evidence if you think it is worthy of acceptance, unquote. The appellant was convicted by the jury and appealed to the Court of Appeal. The Court of Appeal interpreted the material part of the trial judge's summation as suggesting that when the judge referred to a witness who was, quote, lying, unquote, the judge really meant a witness whose evidence contained one or more discrepancies. And so, the Court of Appeal, treating Carter's untruthful testimony as a mere discrepancy, did not find it necessary to cast doubt on the validity of the Canterbury direction. The Court of Appeal held, moreover, that having regard to all the circumstances, the verdict of the jury was neither unsafe nor unsatisfactory, and that even if the offending direction taken out of context may amount to a material misdirection, no miscarriage of justice had occurred. The appeal against conviction was accordingly dismissed, but the sentence was varied to 11 years. The appellant appealed his conviction to this court. Counsel for the appellant asserted that the proper direction to the jury should have been the direction approved in Scantlebury and followed both before and since then by most, but not all, trial judges. A majority of this court held that a blanket direction requiring the discarding of the entirety of the evidence of a sworn witness who is found to have lied in one particular under oath blurs the role and function of the judge and jury to an unacceptable degree. It makes no attempt to convey to the jury that the extent to which the lie is material to the issue for determination at the trial might be a factor for their consideration. Further, it introduces that direction an unwarranted distinction between prosecution and defense witnesses, and it is not consistent with best practice in directions to juries on matters of this nature. The majority emphasized that the categories of evidence which are admissible are matters of law for the judge, while the weight to be placed on admissible evidence is a matter of fact for the jury. It is therefore entirely permissible for the judge to point out that the fact that a witness has lied under oath or affirmation is relevant to the reliability and credibility of that witness, whilst leaving the ultimate decision on the weight to be given to the evidence, to the jury, left to the jury. At the same time, it is also permissible for the judge to direct the jury to guard against assuming that the fact that the witness had lied about one matter must mean that the witness must automatically be taken as having lied about something else. On the question whether the principle of stare decisis required this court to refrain from overruling Scantlebury, the majority noted that the court was not bound by previous rulings of the Court of Appeal on this issue, and neither this court nor its predecessor, the Judicial Committee of the Privy Council, ever had occasion to examine and pronounce on the impugned direction. The court clarified that that direction is not proper and that the direction to the jury on a witness deliberately lying on oath should indicate that the jury are entitled to disregard so much of the evidence as they found untruthful and accept so much of it as they found to have been truthful and accurate. The appeal was dismissed as it was found that the trial judge had not misdirected the jury. In a dissenting judgment, it was the opinion of Mr. Justice Burgess that the issues in the appeal could be easily decided based on stare decisis. His view was that the principles of vertical and horizontal stare decisis dictated that the trial judge was bound to follow the standard direction laid down in the Court of Appeal precedents and in multiple High Court decisions. Whatever the trial judge's own view, he or she had no choice but to follow those directions. It was suggested that this court should not overrule the Scantlebury direction because to do so could compromise the advantages of the stare decisis doctrine. There was no sufficient basis for overruling that standard direction in this case, and there is a procedure available to the DPP to seek the opinion of this court on the standard direction. Utilization of that procedure would not require this court to ignore breaches of the stare decisis doctrine by the Court of Appeal and the trial judge. Ultimately, the court dismissed the appeal and prescribed model directions for trial judges to adopt and adapt when directing a jury on how to treat with a witness who is found to be untruthful while giving evidence on oath. The court will now rise and we will return at 10 a.m. to embark upon the appeal, the application that was made in the case of Tasker.
Hear the attorneys? Hear the attorneys?
All rise. For the President and judges of the Caribbean Court of Justice,